Please be seated.
Thank you.
Good morning, everyone. Thanks for being here. We have two cases set for oral submission this morning. Our first case is PD 0479-25, KENDARIUS Williams versus State of Texas. This case comes to us out of Tarrant County. We will hear first from counsel for the appellant, and I believe that will be Heather Lytle. Ms. Lytle, you have 15 minutes opening, and you've reserved 5 for rebuttal. Is that correct? Proceed at your leisure.
May it please the court, counsel for the state. My name is Heather Lytle, and it is my honor to speak to you this morning on behalf of KENDARIUS Williams. Mr. Williams is entitled to a new trial because the trial court and the Second Court of Appeals allowed the state to use inadmissible character evidence to convince the jury to convict him simply because he is a shooter, not the shooter in Derek Johnson's murder. You have graciously granted review of 4 questions, and I'm going to condense those as much as I can this morning. First, we'll talk about questions 2 through 4, which in the brief are actually 1 through 3, to make that confusing for you. We'll talk about those together because those stem from a single point of error that was raised in the court below, and that is the wrongful admission of accomplice testimony that Mr. Williams allegedly participated in 2 extraneous shootings prior to Johnson's murder. So as to the first question for this court to answer, those extraneous shootings cannot be same transaction contextual evidence, as the trial court held and as the Second Court of Appeals held, and as the state argues this morning, because they're not connected factually to Johnson's murder in any way at all. In other words, nothing about the prior 2 shootings that Mr. Carson testified about provides any actual evidence to
Don't they provide some context, though? I mean, they tell us about what he did that day.
Yes, they do. Admittedly, they provide some background contextual evidence.
Is that the test?
I'm sorry?
Is that the test?
I think it is partially, yes. The case law is really clear that in order to be same transaction contextual evidence, the extraneous and the charged offense have to be so interwoven or connected that you can't prove the charged offense without proving the extraneous. So background contextual evidence is something that might be marginally helpful to the jury to understand something about the day or something about the defendants, but it doesn't speak to any element of the actual charged offense.
Wouldn't your argument be much stronger if the shootings that you were pointing to or that the state was pointing to took place, say, in a different city, on a different day, maybe even months or years prior to this event or even after? Wouldn't your argument be stronger in those situations?
It would.
So how do you account?
Does that mean that this argument, though, is not as strong?
No.
Right.
But
Strong enough.
when you
Yeah.
look at, are you relying on Rule 403?
For this argument, we're relying on Rule 404
Okay.
because we're talking about what 404 excludes as propensity evidence.
Right.
And case law is also clear that if
But
it's
404B in its text allows for lots of other uses for purposes other than establishing conduct in conformity with character, like identity, common purpose, plan, scheme. I mean, the trial court has to make that judgment on the spot, right? And
Yes.
unless we have identity stipulated to the fact that they have 2 shootings on the same day involving similar or connected people, couldn't a trial judge at least find some? I'm not weighing yet how much probative force of that independent of character, but if there's some, aren't we then dropping into 403 to weigh the unfair prejudice risk, meaning character, as against the probative value for any purpose other than character?
Right. I'm going to answer that in 2 ways. One is, and that speaks to the state's argument that it does prove identity, and it doesn't. But even if it did marginally, then yes, then we get to our 403 argument, which is another
But
question.
even if it's, forgive me, a scintilla, a barleycorn of relevance towards identity, then how do we say it's abuse of discretion unless that probative value is substantially outweighed by the risk of unfair prejudice?
I think you get to abuse of discretion if the facts before the court at the time that it considered the argument don't prove identity. What the state is arguing is that it proves his identity because it's a group of guys who are allegedly going around shooting people or shooting at people.
Counsel, when you say group of guys, one of the first words out of your mouth, one of the first sentences you said was a shooter, not the shooter.
Yes, sir.
And that got my attention immediately. A shooter, not the shooter. Doesn't that immediately put identity into issue?
No, because what I mean by that, Your Honor, is, and if you reading through the record, the state admitted pretty clearly why it wanted this evidence, as well as the photographs that are raised in a different issue. And they said repeatedly, this goes to his identity as a shooter, as a guy who shoots, as a guy who owns weapons, and a guy who likes to shoot guns. This goes to his identity that he puts himself out to the public as a shooter. So when they speak of identity, they're talking about how he identifies himself. They're not talking about who shot Derek Johnson.
So your position is that if he self-identifies as someone who shoots people and he's accused of shooting a person, those aren't related?
I believe that is propensity evidence, as
Sure.
this court has talked about in Hart.
It's like he's a thug, so therefore we can introduce evidence that he's a thug.
That's right.
But he's a shooter on this day. How's that different?
Because he allegedly shot at someone else on the day, doesn't prove any element that they have to prove that he shot Johnson.
Well, then focus on the elements then. Is there any evidence in this record from which the jury could infer that the weapons used in both shootings were the same? Either the same weapon, the same caliber, the same look?
No.
None
because-
whatsoever?
No, because in this case, the police never recovered the weapons.
But didn't the accomplice identify what he thought the weapons looked like?
He described to the police a black and silver semi-automatic. In front of the jury, he said the word pistol. It's important also to look at when did the accomplice testify. He testified before the bulk of the direct evidence. And his testimony was that he was there and participated in the charged offense. So he provided direct evidence of identity. He said Mr. Williams was in the car and shot that guy. So the state had direct evidence, and they had other circumstantial evidence. So the case law is pretty clear that if there isn't anything but circumstantial evidence, and the state needs evidence of identity, then perhaps an extraneous can provide that evidence if the extraneous actually develops a pattern, which is like a signature, a calling card, something that actually goes to identity. Like if,
Zorro.
right, Zorro is a great example. Thank you for that. I was trying to think of one. Like we all see those TV shows with serial killers who leave a playing card or something, something like that says, we don't know who did it, but because it was done in this way, just like this, and we have evidence that the defendant did something else just this way, just like this, then we can prove identity.
That takes you back to Judge Yuri's question a minute ago. I mean, you had 2 shootings on the same day in Fort Worth. I mean, that's kind of a pattern, isn't it? I mean, how many shootings do you have in a typical day in Fort Worth?
Well, I don't know the answer to how many. I don't know, Judge. If the court would have granted the motion to change the facts, then that would have helped us. I will admit that because they're close in time, that is something that leans in favor of the state's argument.
But again,
But it isn't everything.
as you said earlier, the trial judge needs to make that determination at the time, and there is a thing called conditional relevance where the judge has to make the decision of whether this could be relevant, hear some testimony, and then in theory could revisit the question, strike the testimony, and order the jury to disregard, right?
Yes, in theory that could happen. At the time that Mr. Carson testified, he was the fifth witness. The state had not presented the bulk of its evidence yet. It started its case with extraneous offense evidence from an accomplice that wasn't corroborated, by the way. The extraneous offenses were not, which also lessens its probative value. So the point of it can't be the same transaction because it was pretty easy for the state to have presented its case without it. They could have put Mr. Carson on the stand and say, I spent the day with these guys, then we drove over, they told me to drive over there, and I saw them shoot him.
What is the difference between prejudicial impact of evidence and undue prejudicial impact?
That is a good question. Obviously, you're welcome. Obviously, all extraneous offense evidence is prejudicial. It's harmful. So we're not trying to ask the court to say that it's not fair to produce bad evidence against the defendant. Undue prejudice comes, and obviously 404B excludes evidence that has the danger of undue prejudice, not that it actually did. A good,
Let me ask you this. It seems to me that this Carson witness was pretty important, not just in the extraneous evidence, but also in the actual charged offense. I mean, doesn't that kind of give your argument a problem? Because basically, it seems like a lot of the case, if not the whole case, kind of depends on whether or not you believe Carson. So on the one hand, you're kind of saying, well, they didn't need the extraneous offense, they had this Carson guy, but on the other hand, he testified the extraneous offense. So if they think he's a big fat liar, then I mean, we're not having this argument because we're not here because he didn't get convicted. Just explain to me, how concerned should we be that the same person who provided the bulk of the evidence for the charged offense is the same person who provided the bulk of the evidence of the extraneous?
I think the jury should have definitely been concerned about that, as you pointed out. I don't know that factors into a review at this stage. Yeah, and his testimony was important to the state about the charged offense. The state argues, and the Second Court of Appeals held that that they needed his testimony about the extraneous. And the reason that they said, both the state and the Second Court of Appeals, and this goes to the question number 3, the reason that they said they needed it was because, well, those prior shootings proved that he's the kind of guy who would have committed this offense. But both the state and the Second Court of Appeals have argued that it was important to the state, it was important to their case, and it's probative because it's propensity evidence. The state didn't really respond to that argument that we raised in our brief because they made the same argument. And that is the question that I think is really the one that the court needs to answer, is, as we've talked about, extraneous evidence is inherently prejudicial. And to go back to answer your question, what's the difference? This court has answered that question well. Actually, it was citing U.S. v. Figueroa, which is a Second Circuit case. But it says the prejudicial effect which is the undue prejudice, may be created by the tendency of the evidence to prove some adverse fact not properly at issue or unfairly to excite emotions against the defendant. So it's not just that it's prejudicial. All evidence is prejudicial against the defendant.
Relevant evidence, right?
Right. It's that if the extraneous evidence has a tendency to prove an adverse fact that's not properly at issue. Well, in this case, that's exactly what the state said they wanted this evidence and the photographs to prove that he's the kind of guy who goes around shooting at people. So obviously, he was there when he shot at Johnson. They wanted, in a way, we kind of raised this in the reply brief, they wanted the evidence from Mr. Carson to bootstrap the evidence that Mr. Carson gave.
I know you're almost out of time, but I've got to ask you to clarify for me.
Yes, sir.
Very distinctly, the difference between he's the kind of guy that goes around shooting people versus he's a guy who was shooting people on this day. I mean, to your mind, there's no distinction there?
Yes, there's some distinction, but it's a distinction without a difference for the purpose of 403.
Okay, and why do you think it's a distinction without a difference?
Because
He wasn't
the
charged.
fact that if he committed a crime earlier that day that has not been charged by the state, then he is not on trial for that. And the jury can't consider, well, gosh, he committed these crimes already as evidence of the guilt of the charged offense.
And they can't consider it for the purpose of he had a gun on this day.
Did he have the gun? Nobody said he did.
But if he had a gun on the day that someone was shot, isn't that a fact that supports, to some degree, the state's case against him?
No,
Not at all?
not enough,
Okay.
not enough.
I see you're almost out of time. I just want to ask, there's no rap videos or anything that this guy participated in that we need to worry about?
Not this time.
He is not hanging out with Block to Fufu or anything like that?
No.
Okay.
No, unfortunately, it's not Mr. Hart all over again.
Yeah, that's right.
But it is a similar analysis that I hope the court would
That's
give.
kind of why I asked. That's kind of why.
Yeah.
But just to get back to the big picture here, I mean, what we're reviewing are not positions the lawyers have taken at various points in this case. It's about the decision the trial court made at the time. And our obligation here, is it not, is to apply abuse of discretion to standard. And if the trial judge could have admitted this testimony on any basis, our obligation is to affirm unless it's an abuse of discretion, right?
That is correct. And we believe on the record, to answer this briefly, and then I'll sit down. The record before this court and before the second court shows abuse of discretion because it shows a decision that is outside clearly established law. And especially if this court is looking at what did the trial court know at the time.
Thank you very much. You have 5 minutes for rebuttal. We'll hear now from Ms. Ford for the state. Or I'm sorry, Ms. Ford Oblon.
Ford Oblon, either, both, one, I go by whatever you would prefer. I'm a prosecutor from Tarrant County. May it please the court, I'm a prosecutor from Tarrant County, and I have the pleasure to represent the state in this case. I did want to begin by thanking the court for setting this case on the June 3rd setting instead of the May 13th. The court may be aware I had a vacation letter, and my 4-year-old was very excited. We did not have to cut our trip to Disney World short. So thank you for setting us today. To kind of go where Presiding Judge Schenke, you were leaving off, the court is reviewing the trial court's decision to admit the contested evidence on an abuse of discretion standard. So we are looking at, and this court will have to ask, whether the circumstances of this case and the evidence in this case was within the zone of reasonable disagreement to admit based on this court's precedent and other other case law before the trial court and the arguments before the court. Based on this court's precedent, the trial court properly admitted I'm going to start with the 2 uncharged shootings, the uncharged shooting evidence under 3 independent 404b2 purposes. The same transaction contextual evidence, identity, and plan. All 3 of these arguments were made in the trial court on page 6, in volume 6, page 155 of the record.
Counsel, what was the plan? I mean, how are the 2 things connected? Was it just he's like Starkweather and he's running through the Badlands killing everyone he wants? Or was there motive? Was there something like that ties these 2 things together besides the fact that they just occurred close in time?
Well, and before you answer that, who decides what the plan is?
Who decides what the plan is? I think the facts of the case demonstrate whether or not there was a plan. And there does not need to be a specific motive connecting the cases. This court has never required a specific intent or motive between charged conduct and uncharged conduct to qualify as same transaction contextual evidence or to show a scheme or plan under 404b2. The facts of the case demonstrate that. In this case, it was very clearly a plan. Mr. Carson picked Mr. Williams and Mr. Holmes up from Mr. Holmes' house. The 2 men had their firearms on them. The first stop of the day was Mr. Carson believed that they were going to buy marijuana and it was just going to be a day of driving around, purchasing drugs, probably taking drugs.
So this wasn't Mr. Carson's plan then?
It does not appear to be Mr. Carson's plan, but based on Mr. Carson's testimony at the trial, the hearing that the trial court had outside the presence of the jury, it's clear that Mr. Holmes and Mr. Williams did have a plan. They got into Mr. Carson's vehicle. They both had their firearms that day. The first shooting, they specifically directed Mr. Carson towards this gray vehicle. When they lost it, they continued so they searched the neighborhood to find it. While Mr. Carson was not, privy to conversations Mr. Williams and Mr. Williams and Mr. Holmes had prior to getting in his vehicle, it doesn't take too far of a logical leap to infer that they had talked about targeting this specific vehicle. Similarly, in the second shooting, when Mr. Williams got out of the car and Mr. Carson heard shots fired. Mr. Holmes said, nope, we're waiting on him. Almost, the testimony seemed as if he kind of knew what was going to happen, that he was waiting for his partner in this crime. And then.
But I'm still not seeing the connection between following one particular car and then saying, we're gonna wait for the dude after another shooting. I'm not seeing the connection between those two things.
And I will admit, the connection on the second shooting is a little less tenuous than the first shooting and the
Yeah, there's definitely a plan for the first shooting.
Yes, and so I do recognize that, but I do think that it shows that they were working together throughout the day. And one of the factors, one of the circumstances of this case is the fact that party liability was at issue. There was no dispute. Mr. Johnson was only shot once. It was one shot, so it wasn't that he was riddled with bullets and both of them could have been the shooter. It really was a question. And so to kind of answer some questions of what is a shooter, I think in the context of this case, either one of them could have been a shooter in this offense. Not generally speaking, a shooter in life and other days and things like that, but
Shot caller.
but that one of them was a shooter in this offense. But the evidence that was elicited from Mr. Carson demonstrates that they were working together, that they were parties, they were collaborators in this day of committing crimes.
One of the other listed reasons why this kind of evidence can be admissible under 404B2 is preparation. And to commit this crime, he had to have a gun. He had to be a person who was willing and capable of making the gun fire. And so it showed that he brought a gun with him, that he had a gun, and that he fired it, right?
Yes.
So preparation is something that I can't sort of, I think maybe that needs to be included in the discussion as well, because even if there isn't a plan, there certainly is preparation.
I very much agree with you. I will note that at the trial court, the three listed purposes by the state were same transaction, contextual evidence, plan, and identity.
Is the trial judge limited by that? If the trial judge, can the trial judge perceive on its own reasons why the evidence might be admissible, even if the prosecutor who's offering the evidence doesn't orally state that on the record at the proceeding?
I think the trial judge can consider it. I know that there is, whether or not that was the law applicable to the case as far as defense opportunity to respond to that
Aren't we reviewing
specific.
the decision that the trial judge made?
Yes.
And once
Yes.
the trial judge has made a decision, aren't we obliged, if the record and the law supports it, to uphold?
Yes.
But
That's
that assumes that this isn't character propensity evidence.
correct.
So if we think that it's just character evidence, then the judge did abuse his discretion.
Only if it's just
Only if it's
character
just. If it
propensity.
has
And
this
if,
other limited
fair enough,
purpose,
and if it's
yes.
undue prejudice because we're trying another murder in the middle of one.
Right,
murder.
right. And those are distinct analysis, whether it is,
And that's how the judge could have abused his discretion.
if it is both character evidence, it is not admitted for one of the limited purposes under 404B2.
So
That's one way.
just because there's an abuse of discretion standard doesn't mean that we're unable to actually say the judge abused his discretion.
That's true, that's
Right.
true. Absolutely, and that's why we have these standards
That's right.
of review, exactly. And when we are looking at that, we are looking at the information that is before the judge at the time of the ruling, and the facts of this case. And, when we're looking at this zone of reasonable disagreement, and that is the standard of what abuse of discretion is, the trial judge is guided by this court's opinions and can take guidance from other courts of appeals opinions as well. And throughout this court's precedent and other intermediary courts, they've noted these kind of factors to consider, circumstances that have been applied in other cases. And this case checks almost all of them, that the uncharged conduct demonstrates the beginning course of conduct throughout the day, that there was no real rest between the offenses. The same weapon, and I know there has been discussion of that there is no ballistic testing in this case, but Mr. Carson testified it was the same weapon. It was the same weapon used throughout all of these shootings. He had it at the beginning of the offense, and I think when we look towards the necessity of the shooting specifically, and not just the fact that they were all together, Mr. Carson didn't necessarily, he didn't testify that he saw that they had the firearms with him when they got out of Mr. Holmes's house. So the fact that he saw them use them twice earlier in the day, and then he once again saw them, both of them use those same firearms, that is one of those circumstances that leads more towards same transaction, contextual evidence, and plan as well. And I would say identity as well as a participant in the charged offense.
Counsel,
yes.
you've made it pretty clear that, these other shootings were probative at least, but I hadn't heard much about prejudicial from you, so.
I'm happy to address that. When looking at, and again, as Ms. Lytle pointed out, it is not just prejudice, we are not just looking at prejudice, it is unfair prejudice. And we look at that, we're looking at whether the evidence is going to impress on some irrational yet indelible way on the jury. Typically, that's an emotional response, or whether the jury is ill-equipped to judge this evidence. And in this case, that's just simply
Well,
not.
is that all it is? I mean, it seems to me, I understand your argument on getting through one piece of 404B, now you're cooking with gas, but isn't the weight to which you got through the 404B window relevant? I mean, because it's got to be relevant to either context or identity or motive or something else, but if it's pretty thin, I mean, you're talking about weighing, it's a balancing. And the unfair prejudice here can be, he's a scary guy, right? I mean, just who he is. The risk under 404B is still, isn't that carried over into 403?
Yes.
That the jury might be inclined to convict the person not because of the evidence on the charged offense, but because he's scary.
Yeah, so that is definitely part of the weighing. And to get to the 403 analysis, we will have to already have determined that this does have at least some probative level. It was relevant and admissible under 404B2, and that is where we weigh whether it is enough that it is just this scary. And in this
fairness,
case,
There's,
the judge's question, I think that's where you've got work to do, so.
Right.
I'm
yeah.
happy to talk
well,
about
to
that.
add to this, too, there's one thing I haven't heard so far about an additional thing about prejudice, undue prejudice, is also the potential to distract the jury from the charged offense. If you're having a whole trial on one shooting in the middle of a trial about another shooting, then how's the jury supposed to, I mean, it creates can create a significant risk that the jury's gonna make their decision based upon the plan from the first shooting instead of the second one.
And I think that can be the case. I know that this court has handled cases where there's 4 days of testimony and 3 of them are on an extraneous offense. And this court
Yeah.
has had very little trouble saying, that very clearly outweighed. That's not the case here.
Okay.
There was, in front of the jury, there was only 25 pages of testimony that related to this.
Okay.
When Mr. Carson was talking about these shootings, it was very matter of fact. There was no photos or pictures of these other shootings. We don't even know if there was actually any victim of these other 2 shootings. None of that was before the jury. So the information that was relayed to the jury and how it was relayed really does diminish that, the prejudice that could potentially be there.
Undue
if-
prejudice.
The undue prejudice, if too much time was spent on it, or if we were talking about two gruesome.
Was that part of the
shootings.
argument, though? I mean, did they argue the second shooting, both shootings in the argument, closing arguments?
In closing arguments?
Yeah.
This prosecutor noted that the state was allowed to introduce them because it went to show the intent of Mr. Williams on that day to engage in these offenses.
Counsel, can I ask a question? I want to shift gears on this. One of the state's alternate theories of admissibility is that it was admissible to address a defense theory, either the defense statement or an alibi theory. But applicant has argued that the defense didn't raise that theory, the state did through Officer Stetler's testimony. How does the state address that?
I agree with that point. Detective Stetler's testimony occurred after Mr. Carson's testimony. That was not before the court. I actually went and talked to my trial prosecutor when the opinion came out, and I was like, alibi, huh? And
So is the state disavowing that particular ground?
that specific defense
Okay.
of alibi, yes. But throughout the trial, and specifically before Mr. Carson's testimony, Mr. Williams repeatedly questioned his connection with Mr. Holmes and whether they were friends, whether they would, hang out. He specifically in the record, on cross-examination, volume 6, pages 99, 119, and 136, specifically questioning jurors about this relationship between the two. And so in this instance, demonstrating that not only were they together that day, these shootings don't just show that they were together, but that they were willing to engage in criminal conduct together, and that they were directing an individual to these locations to engage in this criminal conduct together. And so as far as rebutting a defensive theory that I don't know these people, which is really a question of the identity of the defendant and as a participant in the offense, this evidence does very strongly go against that.
Counsel, who was the trial judge? Do you remember?
Trial judge, I believe was Justice Gabriel. I'm unsure of that.
Someone honorable, no doubt.
Someone honorable, a very respected judge in Tarrant County, of course. To kind of talk about the prejudice just a little bit more, because that seems to be something weighing on the court.
Before you go, I want you to go there.
Okay.
But I want to make sure that I'm clear about something. When we're talking about prejudice, are we talking about that in the context of some language found in 404? Or are we talking about it in the context of language found in Rule 403?
Rule 403.
Okay,
When
I just want to make sure that we're clear.
Yes.
That 403 is a big part of this conversation.
Yes.
And I wonder whether, if your whole argument, if a party's whole argument is based on Rule 404, then do you even get to 403? Or, you have to go to 403 at some point to be where we are. Does that mean that we've already satisfied 404?
Yes, that, based on how this court has typically handled these evidentiary, in most cases, you'll get a 404 objection and a 403. In most cases, if all of the cases that I have reviewed, this court does conduct a 404 analysis. And in looking at 404, it is just looking at whether it is propensity evidence and whether it fits one of those limited purposes.
Right.
And that is the confines
But-
of
but-
404.
It seems like the argument in this case, from my perspective, I'm kind of seeing it more as a 403 argument, because everybody's talking about undue prejudice. And so, you can speak to that, and I didn't mean to, I guess, mean to interrupt what you were saying, but I want you to carry on, and
That's
please
fine,
say.
and I completely understand that train of thought. We do get into 404, kind of satisfy that. I think the analysis from 404 carries through to 403 when we're looking at that first Giglio-Bianco factor of what the probative value is, and we use the analysis that we did in 404.
That's the point of balancing, right? I mean,
Yes.
the illicit
Right.
purpose for 404B, if it substantially outweighs the probative value for some legitimate purpose,
Yes.
it's the trial judge's job to say, no, I'm going to strike that out. Or, and this is another question I had, there is a possibility of a limiting instruction to the jury. Did anybody ask for that here?
No one asked for a limiting instruction, no, and that does raise a really good point of whether or not this error was preserved. This court has held that in Delgado v. State, it's 235 Southwest 3rd, 244, that if a limiting instruction is not requested at the time evidence is admitted, the trial judge is not required to limit it at, and that once evidence is admitted for all purposes, generally, it may be used for all purposes by the
That
jury.
would be for sufficiency purposes, clearly, but isn't it generally, I understand that holding your citing against it, but isn't it generally the lawyer's job to pursue an adverse ruling?
Yes.
And if he got an adverse ruling on the 404B and the 403, at that point, he might have an error. I mean, the question of harm would then factor in, as would sufficiency, to whether a limiting instruction might have fixed it. But we do potentially have an error to evaluate, right?
Well, I would say yes. If this court finds that it was not admissible pursuant to 404 and 403, then that would be, and that it was an abuse of discretion to admit it under those, and that would be an error. But if then the defendant did not carry on that burden to request a limiting instruction, because if the defendant gets a favorable ruling on either of those evidentiary rulings, the evidence is not coming in. So a limiting instruction would only come into play once the evidence the trial judge has decided that the evidence is going to come in.
Counsel, before your time is up.
Yes.
Address briefly for me the photographs. There was a photograph of this appellant with a long gun, which I don't believe was ever alleged to have been used in the crime. And there was another photograph one taken 2 weeks before the shooting, and then another 3 months before the shooting. Describe briefly for me, please, the state's position on why those were admissible.
Yes, those are admissible because they corroborate Mr. Carson's testimony. Mr. Carson, again, we do not have ballistics in this case, but Mr. Carson told Detective Stetler that the firearm used by Mr. Wilson in this case was silver and black. The photographs are, I recognize, look like they might be different guns, but they are, most of them are silver and black. One, I think, is just black. But they demonstrate that not only does Mr. Carson have access, or excuse me, Mr. Wilson have access to these guns, but he's regularly using.
Okay, hold on, just let me clarify. If the state's position is that the photographs that were taken weeks or months before, or one day after, were admissible because perhaps they were evidence that this appellant had the gun alleged to have been used. But the two photographs depict different guns, so one of them necessarily can't be the gun used here. And one of them contains a long rifle that there's no allegations whatsoever were used. Doesn't that impact their admissibility?
It impacts the overall balance, perhaps, again, separating 404 from 403, of whether those would be prejudicial or not. But again, I think that it is sufficient within the trial court's discretion to say, a witness is saying that the offense was committed using this particular type description of a gun, and this defendant has regularly portrayed himself and shown himself with this type of gun.
Doesn't that go right back to what Judge Newell was saying? Isn't that sort of exactly what we're looking at here? You seem to be arguing these photographs would be admissible to say this is the kind of individual that had guns.
I don't believe it's the kind of individual that had guns.
Or this is someone who had guns.
I don't believe it's the kind of individual or the kind, I wouldn't say that it's that broad, because they fit the description made and described by Mr. Carson.
Long rifle doesn't.
No, but I believe the long rifle was in the photo with the three gentlemen, and that photo.
He's the kind of person who has guns. I mean, this is Texas, right? I mean, how prejudicial is that in this state?
And I would also note
How
that these.
probative is that in the state?
I think it's the better question.
He got into his car because he had a gun. How often does that happen on a Saturday night in Lubbock?
And I would say the photo with the three gentlemen, specifically, that also goes to not just this specific gun, but that he was friends with Mr. Holmes and that he was with them, months before the offense.
I believe we have another question.
I just have one more question. So just hypothetically, if we were to go and say that this evidence was substantially more prejudicial than probative, could we also in the same breath say, but it was harmless?
Yes, and that is something, and this court, if I may continue.
Of course.
Okay. And that is something, traditionally, this court will remand to the Court of Appeals. The Court of Appeals did not conduct a harm analysis because it found on error, and traditionally, it is this court's practice to remand for the intermediate court to conduct a harm analysis on in the first instance. On the facts of this case, we do believe that they are the admission of all of this evidence would be harmless given the remaining evidence, and particularly Mr. Williams' consciousness of guilt based on his Instagram photo post after the offense and offering Mr. Carson $20,000 not to testify in his trial against him.
Thank you.
So for the reasons stated today, the state would ask the court to affirm the Second Court of Appeals and the trial court's decision in this case. Thank you.
Ms. Ford Oblon, thank you very much. We'll now hear again from Ms. Lytle.
So I think that the main question here then is the 403 question. Going to Judge Richardson, you asked me earlier, if there's a scintilla, then doesn't it get?
Judge Shank.
I'm sorry.
Judge Shank,
It was you. Judge Shank.
I don't think I asked you any questions.
Yeah, I'm sorry. Your pictures are next to each other as you are also sitting next to each other. And you're both so handsome. So,
Yeah, there's a scintilla.
a scintilla, yes. Back to
Potentially
scintilla.
moves you through, but there's
Right,
Barley corn.
right. So, if there's a scintilla, can it get in under 404? Sure. But then we look at 403, and if we only have a scintilla, if it's only a scintilla, if it's only barely probative, then that has to be weighed against the prejudicial effect. And in this case, the prejudicial effect substantially outweighs any sort of scintilla of probative or relevant value. And I think this court you're looking at abuse of discretion at the trial court, but you're also reviewing the second court's decision and their reasoning. And they specifically found it probative because it's propensity evidence. That's specifically what they said. And this court just has to correct that analysis. It's an unpublished opinion, but the Second Court of Appeals will continue to follow its own precedent, published or not. And that analysis doesn't come into play ever, that it's probative because it's propensity evidence.
Counsel, focus on harm for me. I'm sorry, Judge Richardson, go ahead.
I do have one question or two. Was there a limiting instruction requested, and was there anything put in the jury charge related to the extraneous offenses and the state's burden?
The limiting instruction was not requested at the time that Mr. Carson testified or at the time that the photographs were admitted, but there was a limiting instruction in the jury charge.
Okay.
I have a side note question. Isn't it true that there was photographs and Instagram posts related to firearms admitted in this trial?
Yes.
And nobody's talked about those as if, well, they're not guns, but there was pictures of guns.
Right, and that's the last question before this court, and I can talk about it briefly. I do want to encourage the court to consider, so obviously each photograph can be a separate point of error. We presented them together as the cumulative harm. It didn't specifically argue cumulative harm, but they were presented together, and the harm is discussed as all of them together. The photographs, we don't know that they're actual guns. They could be airsoft rifles, they could be pellet guns. We don't know what they are, because no one testified as to what those weapons are. If those were the guns, or if any one of them was the weapon used that Carson allegedly saw him use, they certainly could have asked him that. They could have said, isn't this the gun? But they didn't. They didn't ask him. No one could connect those various firearms to this specific crime. And again, the state argued over and over and over and over again that those photographs were relevant to prove his identity, his self-imposed identity as a shooter, just like in Hart, that it showed, well, he's the kind of guy who writes violent rap music, so then he must be guilty of a violent crime.
Counsel, talk about harm for me.
Thugging all his life.
Yeah.
Harm, I want to focus on harm.
Okay.
Would you concede that any harm here is non-constitutional, or excuse me, any error here is non-constitutional?
That's correct.
So we're looking at 44-2B.
Yes.
Okay, so we're looking at substantial rights affected, substantial and injurious effect, influence in determining jury's verdict outcome, right?
Yes.
Well, the problem that I've got here is assuming that this was error. When we go to harm, if I read this court's prior precedent, as long as we were to conclude that it had but a slight effect, there is no harm. So I want you to focus on harm for me here, assuming for the sake of argument that it was error to admit these various things. Why do you contend that it's harmful?
Okay. I contend that it is harmful because it had more than just a slight effect.
Why? Why does it have more than a slight effect?
The state presented its entire case and its argument to the jury, by the way, that all of this stuff happened together. All of this stuff they said to the jury, the reason we're allowed to tell you about these things is because it shows you his intent, not his identity or his plan or his preparation or that, gosh, he's really friends with these guys. They said, no, it shows you his intent. He intended to kill Johnson because he's a guy who goes around shooting at people.
Well, wait a minute. We go back to intent. If I read this right, and I may be misreading some of the lingo here, but one of these Instagram quotes where I know, we don't FW, we each other, but tell Splurge that I handled GHG Kane. Now, GHD is Grindhouse, Kane is Johnson, and GHD is the gang he belongs to. So tell Splurge I handled Kane for him. And one of the others was, it's done, GHG Kane, with a coffin emoji. I mean,
Those certainly show, if those are attributable to him,
They're on his phone.
They're on his phone.
He said he kept possession of his phone.
Yes. So if those are, that certainly shows at least knowledge, at least knowledge.
Could the
Yes.
prior shootings be admissible to show intent on the basis that in those prior incidents he missed, but on this occasion he hit the victim?
No. Because on the, first of all, let's be really clear about what the facts are on the priors. What Carson said happened was they shot at a car as they were driving by. The second one said, Williams got out of the car and I heard shots. He doesn't know who shot at whom. He doesn't know if the other unknown individual got out of the car and fired the weapon. So again, this is just kind of going to general criminality.
Right, but if you have so there's an intent to kill element, right? And so sometimes if you, let's say you have a gun and you go out to go shooting and you shoot it in places where you shouldn't shoot it, but it's into trees and into the ground, and then finally the last time it's into the back of a human being who dies from that wound.
At close range.
Yeah, does that not then, I mean, can you not demonstrate that in certain instances, he did not have an intent to kill because after all, no human beings were actually affected by the bullets, but in this instance, he put a bullet inside of a human being and caused their death. Doesn't that tend to demonstrate an intent to kill?
No, I think it tends to demonstrate the opposite. As we argued in the court below, but not in this court, Mr. Williams should have been, or the jury should have been able to consider manslaughter because there's evidence that there was.
But we're not talking about a denial of a lesser included offense instruction.
No, we're not. But you're asking about intent. And so if if it's rightfully before the jury, then the evidence is earlier he shot at a car. He didn't hit, there's no evidence that he hit anybody. There was no police reports, the cops didn't come and testify that we have victims and bring them to identify him or anything like that. And the second one is I heard a gunshot. Again, there's no evidence anyone was shot. Here, the state has to prove intent in one of two ways. Either I intended to kill Johnson as a party or as a principal, or I intended to cause serious bodily injury.
Well, it's not just intent, right? It's knowing also will get him.
Right, and knowing. So those other things don't prove, they don't speak to his intent with Mr. Johnson. They kind of show, my friends and I ride around and we fire off our weapons with no intent to harm. And perhaps that was the same here, you know? They don't show a specific intent in this offense. If it shows intent, we're right back to, it shows that he and his friends are criminals generally, and they drive around committing crimes.
Counsel, back to the photographs of the guns. Were those was there evidence as to when the photographs were taken? Were they taken the same day as the offense or months earlier?
Some were months earlier, some were weeks earlier. I think there were one or two that were a day or two earlier, but some of them, Your Honor, don't even show his face or the person's face who is holding these weapons. So the fact that he may have possessed an object that looks like a firearm, and again, we don't know if it's a firearm or if it's a water gun, we don't know. The fact that he may have had access to those earlier and presents himself on his Facebook I'm old, Instagram, as a proud of owning these weapons or holding them, that doesn't prove anything at all in relation to Mr. Johnson. And that's a lot, extraneous offenses often can go, I know I'm over my time, if I can just finish this one statement. If they're helpful to the jury to tell the story, then it's relevant. We can talk about those things. But whose story does the state need to tell? They need to still tell Mr. Johnson's story. What happened to Mr. Johnson? The jury needs to know what happened to Mr. Johnson. What is the context there? None of this evidence, either the priors or the photographs or Instagram posts, have anything to do with Mr. Johnson. They don't help the jury at all to understand what happened to Mr. Johnson and why. The state presented that evidence clearly. What it does is distract the jury from the crux of the offense, which is Mr. Johnson.
I know you're very close to the end of your time, sort of over, but I just try to get my brain around this. After this happened, someone using the appellant's phone
Yes.
posted, "I killed him last night." And your position is that shouldn't have been admissible.
I believe we argued about the photos. I don't think that we argued that that one was inadmissible.
All right.
I mean, I believe I wish I could argue that that was inadmissible.
I'd love to hear how you could.
Right,
But she's not.
right. I think it's important to know one's limitations, Your
Okay.
Honor. So with that, I appreciate your time, and Mr. Williams appreciates your time. And we'd ask that you would reverse and remand for a new trial.
My thanks very much to both counsel, very fine presentation. We appreciate your help with this case. We're going to stand in a brief recess while counsel for the next case appear and make themselves ready. So we'll stand for recess for just a few minutes.
Good morning. This should be a good one. Should be fun. Good to see you.
right, I will now call our second case for argument this morning, Nguyen versus the State of Texas, number PD 052325. I believe we'll be hearing first from Mr. McCann,
Yes, sir.
followed by, I'm not sure, is it Ms. Presley or Ms. Hagan Doyer? Okay, very good. So, Mr. McCann, you're going to be giving us 15 minutes and reserving 5 for rebuttal, is that right?
Yes, sir.
Okay, why don't you proceed at your,
Thank you. May it please the court, I am Pat McCann, and I am here to represent the appellant, Mr. Nguyen, on a murder conviction out of Comal County. This court has asked 2 questions to be answered. First, does Wells control? And second, does the third-party doctrine apply? The answer to both questions is no, and for the following reasons. Wells is not a binding authority. It is a fractured decision without a clear majority, and it is on final review now. In fairness to the panel and to Wells, the Chatry case, which has been argued before the Supreme Court, is pending and may wind up with us submitting additional briefing to this court and perhaps asking for, once again, to bother you during the fall
Well,
return.
counsel, that raises the big question for me. Isn't this going to be kind of mooted out by Chatry, what the Supreme Court does in Chatry?
I don't think so, Your Honor, because it leaves open several avenues of discussion that we tried to cover in our brief. It leaves open, for instance, where Holder takes us under the Texas Constitution. It leaves open the requirement of the warrant, which is essentially a codification of the Fourth Amendment principles of a particularized finding by a magistrate that's neutral.
Did we grant review of a Texas constitutional question?
Yes, Your Honor, you did not grant it in that, but in this court's recent jurisdiction, it seems clear that this court, if I don't want to put words in your mouth, is interpreting the Fourth Amendment intertwined with Article 1, Section 9. And if one looks at the last holding that we consider significant, which in this case would be Holder, and a prior holding of Richardson that our amicus colleagues briefed, it seems that the technological advances which have brought us to these difficult questions were anticipated in several ways, one of which is, and I don't wish to get off the question, but in Holder, it seems particularly the abhorrence of a general warrant was made clear, it's textually extremely clear in the Texas state constitution that was a concern. That has historical roots.
Can you answer, Judge, I have the same question. Is that question before us because we have a limited amount of time to hear from both parties?
I think this court could place it as a part of where it should go. It does not have to, which is partly why we covered that in our brief, because obviously, to quote my colleague's brief, as Justice Diaz said from the Fourth Circuit, one of the restraints that courts in your position have to exercise is that we don't want to make grandiose constitutional proclamations if we don't have to. So I don't think you have to answer.
Does it turn on what is the decision below at all?
I'm sorry, Eric.
Does the question about whether we can reach it turn on what the decision below is at all, or are we limited by
Well,
the
actually,
objections?
if I can return to that, under your decision in Wells, this fails. Because the officer, Mahoney, and please understand, I have great sympathy for someone who actually attempts to get a warrant. But in the second part of the geofence warrant, he actually did not consult the magistrate and expanded the criteria. Now, that is what led to eventually focusing attention on my client. And that is the problem with the geofence warrant. We believe.
I know you want to get into marriage, and I appreciate that, but I think I would prefer a clearer answer on the question of whether this case properly presents a state constitutional argument for us to entertain before or after Chatry is decided in the U.S. Supreme Court. The question I would have on that is not so much what the Court of Appeals did here, but I believe they may have faulted you for not presenting that First Amendment, that Article 1 argument in the trial court. Was this issue preserved in the trial court, state constitution?
Based upon the arguments of counsel that were cited in the brief, I believe that because this court interprets both, that it was. However, if you wish to confine it to the Fourth Amendment,
Could I interrupt you?
Then-
He's asking you what happened in the trial court. I would like to hear the answer to that. Was it preserved in the trial court?
Your Honor, if you look at the quotes from the lawyers in the counsel, I would say yes. However, if you parse the words differently than we do and you look at it as a straight Fourth Amendment claim,
Okay, I get it. It's a question of how broadly we want to interpret what the words that were uttered in the trial
I
court.
believe the argument actually didn't mention either amendment. It simply went to the,
Unreasonable search or seizure, okay.
so in that sense, if you wish to, you can. If you don't, you can confine this to the Fourth Amendment and Wells.
But Wells, Wells or Chattrey, when they are decided, will they apply retroactively to all cases not final at the time of the decision?
That's a more difficult question, and I think that
That's not a retroactive application if it's, case is not final.
That's my
I'm sorry,
Teague
you
versus
repeat?
Lane, right?
It's,
The question is, will the Chattrey decision be important to this case if this case is not yet finally decided in this court?
Of course, it will have an impact, but I don't think that if this court wishes to wait, it has to. If you wish to take it in order, I think honestly, quite honestly, under the Wells decision, that this warrant procedure fails because of step 2 that the officer did.
But as you said, under the Wells decision, we don't have a rule of decision that's a precedent coming out of Wells, according to you, correct?
I would agree with that. I would agree with that, and I think that that is why we pointed to other aspects that we believe may help the court in its decision, including, if I may, our colleague from the ACLU's brief on separation of powers, because the removal of the magistrate, certainly the particularized requirements, and the historical problems with general warrants. Everyone in this courtroom today, myself included, and respectfully, Your Honors, if you have an Android phone, this warrant searched your phone and your records, because that is how a geofence search works.
As I read the appellant's ground of review that we granted, it said, did the Court of Appeals err by treating Wells as binding authority? And what it made me think of was whether there's any language in the Court of Appeals opinion that carried the weight of suggesting that the Court of Appeals felt bound by Wells, because that would be binding authority. In other words, was there something in there that said that we are required to follow the reasoning of the court's opinion in Wells? Is there anything like that in there? Can you point to anything in there where it shows the Court of Appeals considering it as binding authority?
I think it followed it. It did not specifically, as I recall, the opinion.
Right, but
and
that's
of
not the
course you have
same, is
there.
it? Is it the same if you're persuaded by something, it doesn't mean you're bound by it, right?
No, of course not. If you produce an argument that I find persuasive but is not authority, then that's simply
So
leading
does
me down
that
a
mean
good
that,
path.
that you're conceding that the Court of Appeals did not treat Wells as binding authority?
They didn't say it. It appears from their actions they did.
Okay.
And that's the problem. And it's the question this court put to us. So again, my answer would be it shouldn't. My answer would also be the third-party doctrine doesn't apply.
That wasn't your point of error? I thought that was your point of error. Did we come up with that?
If you could clarify for me, Your Honor.
Okay, so I understood your point of error to be, did the Court of Appeals err by treating Wells as binding authority? That's what your point of error reads.
Yes.
Although you rephrased it at the beginning of your argument.
If I flip it back to the original question, it's yes, they did err.
Okay, but your question assumes that they treated it as binding authority. If we read their opinion differently as not being, bound by Wells, Shouldn't we dismiss your point as improvidently granted?
No, Your Honor, you should consider it because you're going to have to consider it anyway. And I think that's why the court wanted to hear from the parties on this, because at some point, Wells is either going to have to be clarified, overruled, or embraced. Obviously, in your opinion on that, there was.
Is there another point of error that would allow us to consider Wells? Because based on Judge Kill's question and your answer, it seems like we would be finished with any further discussion if the court decided that the lower court did not consider this to be binding authority, the Wells opinion. Is there anything else? Are there any other issues that have been raised by the appellant?
There's the state's petition.
Yes, there were, but they weren't granted on the original question. But I would
they're not
also
before
point
us.
out that the state's brief on it actually raised the third-party doctrine, which I think does not apply in this case. and
Why not?
For similar reasons.
Why doesn't the third-party doctrine apply?
Well, hold on. Let's make sure I want to get the playing field laid out here. Is there not a negative, a pregnant negative in your question presented? If they've treated it as binding authority, then something needs to happen in place of it, right? In other words, can we write an opinion that gets to a rule that the lower courts could follow with or without help from Chatry in this case?
If you're asking, do we subsume that there has to be a follow-up?
Yeah.
I would say yes, but the issue on that is that requires both a clarification and a decision that's going to either be in harmony or different.
But we granted review in this case. And we also have a second question coming from the state on the third-party doctrine, which we've also granted. Right, so here we are. What should we do with respect to the second question or your first question, in your view, in terms of the scope of our review? State Constitution, Federal Constitution, Fourth Amendment, and are we limited by the state's question to the third-party doctrine?
You can do, honestly, quite honestly, with this court's doctrine and inherent powers, the only thing stopping this court from doing whatever it wants to do on the geofence issue under either the state constitution or the federal one is your own restraint. And whether you believe this question is fairly framed by this, I think it gives you a vehicle to do that.
Let's assume that we're now over that question. Why don't you answer Judge Urey's question now? I'm sorry to have interrupted on.
Well, just to
Third-party
bring it back, my question was, why doesn't the third-party doctrine apply?
Why doesn't it apply?
Yeah.
Because very simply, Carpenter has established that the third-party doctrine has limits, and none of the authority.
How do we know those limits go as far as to apply in this situation?
In this situation, Your Honor, geofencing actually gives more complete and scorching data than the cell phone tower information, such that the concerns that were raised in that decision in Carpenter not only apply to this, but apply to a greater degree. I see my time is starting to run a bit short. May I? Very well. If we are going to address the privacy concerns because of the sea change in technology that has occurred in the last 40 years over how much data is collected, whether it is truly voluntary, and whether or not that information is of a nature that would expect a reasonable protection of privacy, I think you have to look at that. And to me, the analogy is not a bank checking account, but a bank safe deposit box.
Do people have a legitimate expectation of privacy in information that they were not at the scene of a homicide?
Yes, and
Put it another way.
And the simple reason is, if I may
No, go
answer
ahead.
Judge Urey's question, is yes, because unless, according to the Fourth Amendment, if you don't have a reason to suspect I was there, then why are you questioning me?
Well, that's different, isn't it? I mean,
No.
You're talking about all the people in the world. You're saying this is such a pervasive invasion of privacy to prove that all the people in the world, except for the killer, were not present at the scene of the homicide. how can that possibly affect, I mean, I'm willing to hear it if you have information about it. How does that possibly affect a person's legitimate interest in privacy that they weren't at the scene of the homicide that somebody else committed?
Because one, this doesn't get there for that. Two, I have a right not to be subject to produce your papers randomly or show me you were innocent. I don't need to be searched unless a police officer has a probable cause that there is evidence on my person or that I contain evidence in my home or my car.
Go broader.
This is a search without a warrant.
Counsel, go broader than what Judge Yeary just said. Do the people in this room right now have an expectation of privacy in their presence in the public?
That is not what that is limited to, though, Your Honor.
Okay, well then why did this individual apparently have an expectation of privacy about the public street he was walking down or the public road he was driving down? If there had been a security camera there to observe him or a witness to observe him, no one would say that the state didn't have a right to the security camera footage or the testimony of the witness. How is it that you can take the position that an individual sitting in this room has an expectation of privacy in the fact that they were here such that the government shouldn't be able to look at the information on a remote server that comes from their phone that they consented to that said they were here?
Or the video cameras in this?
Or the video camera, or the witness?
If I may answer both with this. You don't have the right, perhaps, to be viewed if someone's watching you, but that's not where this information ends. This information includes all the things that we would like to not give up in a surveillance state. And more importantly, the scope of this was actually expanded. This was not a question where the officer attempted to limit and narrow this. This was a place where the officer went back on his own initiative and expanded his request for information. 18 devices were found in this, and then the time period was increased. At some point, Your Honor, how much intrusion are you willing to say? Do you have a right to be not surveilled in your home?
So,
Do you have a right
even,
not to have your medical information given out?
If I leave the windows of the curtains of my front window open, no, I don't have a right to have somebody walking down the sidewalk not look in there and observe me dancing around in the road.
But you're taking this,
In public, you've effectively given up a right to privacy in the knowledge that you're in public.
but you're taking this backwards from what our founding fathers intended. They intended for you to be left alone unless the police had a reason to stop you or search you. This is not that, and it won't ever be.
I have a precedent-based question, okay? So if the Supreme Court seems to be concerned with regard to the third-party doctrine, when the police or the government goes and finds out where you've been driving all day long or all week long, they don't want the government gathering months of data about where you go from day to day. But I don't think they've said the same thing, have they, about gathering information about where a person was on a single instance of time, maybe in about a 25-minute time frame. Have they ever shown concern about a 25-minute time frame, knowing where somebody was in that time frame?
I think the reason they took Chatri is specifically because of that, but you raised a different point,
I'm
if I
trying to draw a
understand your
distinction
question.
between the precedents that they
Is
did.
there a continuum?
Yeah.
Where one's intrusion is minimal and reasonable under the Fourth Amendment? I could see that if it was limited to certain other questions, just location.
Yeah,
But
parameters.
that's not where this goes, sir. The problem with that is movement tells your story. And nowadays, your communications, for instance, are only available by cell phone. I would defy, candidly, anyone in this court to walk 5 miles in any direction and find a landline that was functioning outside of y'all's office, because there is not a payphone to be had.
I have a
That infrastructure is gone.
Isn't the issue here consent, though? And when you have consent to this data being retrieved, that seems to undermine your entire argument.
I don't think so, Your Honor, and this is why. The data that is collected by the cell phone towers and the data that is collected under a geofence warrant are different in quality and quantity. the cell phone towers themselves collect a great deal of data that the Supreme Court has said at a certain point certainly becomes your life story and is the equivalent of surveilling citizens. For geofence data, the problem is, one, that's far more accurate. So whereas, for instance, it might tell you from a tower location that I was within a radius of several miles, it doesn't tell you the office that I visit, the church that I go to, the doctor who attends my needs. It doesn't tell you that everything that your actions did. It says that on a cell phone tower, that at a certain point, your phone was within this 2-mile radius, or this, if it's much more triangulated, within a certain several hundred yards or a quarter of a mile. Geofence is accurate to 20 yards. So that means that I know who, respectfully, you are from geofence data. So it's a fundamentally different qualitative and quantitative amount of information. And to my mind, this goes more now
But aren't you asking the officer to narrow the warrant to this smaller?
The officer didn't do that here, so that
He
question
started
shouldn't
out with
apply.
doing that, and then there's a question about whether he went too far when he went back. That's my understanding.
It is, but
Okay.
that means he expanded the second part without a magistrate. So in terms of Fourth Amendment compliance, again, getting back to the narrowing of this issue, the officer didn't comply. He didn't comply with Wells.
Well,
He didn't
what I'm
comply with the
what I'm
Fourth
looking
Amendment.
for, to be clear, is the focus of the issues. And we've pulled you left and right here, and your time is up, but I would like to ask you a question. You were starting to answer, and I think you got cut off. You went to, the analogy here is more to a bank safety deposit box. And I'm just wanting to make sure the field is clear in front of me. Is your concern with invasion of a reasonable expectation of privacy? I've heard you say that. Or is it also a property interest in data, that the data that is on our phones, which you have been pointing out here today, will include not just location information, but photographs, which might be password protected in a file, as your location history might be password protected? Could you take me back to the point you were trying to make about the
Yes, Your Honor.
lockbox? Are you talking about just reasonable expectation of privacy, or is it also a potential interference with a property interest that in the data, not just of the individual who's actually later proven to be guilty of a murder or appears to be probable cause of guilt of murder, but of everybody whose phone is being searched?
That's an excellent question, and yes is the answer, because there is, certainly Google treats our data as a property interest because they use it to sell us things.
But you
They
give them consent to do that.
No, and let's talk on that, Your Honor, if I may, if that answered your question,
Please.
Presiding Judge. No, because, for instance, if you look at your technology, and please, any technical thing that you wish to challenge me on, I claim vulnerability, but I do understand that, for instance, you involuntarily activate your locating information on your phone all the time. Whenever you use certain apps that either activate your Bluetooth, because that searches for things in a party, that then gives the Bluetooth your location. And that is not in your control. When you seek to use an app to order Domino's, they almost always try to turn on your locator. And if they will ask you to turn on your locator for this. If you are lost in an emergency and you dial 911, some models of phones will apparently turn on your locating
Yes,
information.
but here, we're talking about geofence, geolocation, which the appellant gave consent to Google to collect.
That's my point, Your Honor. No, that doesn't always work. And more importantly, if you wish to do it selectively, it is often difficult, especially for the technically challenged, to sit there and.
Well, I know your time's up, but let's just, one quick question. If we're talking about balancing the intrusion, right, on the individual, if we're talking about balancing, what your client had to do, like you used the example of, do I want to be surveyed in my home? And I said, if I got an open window, people can look in. If I don't want them to, I close the window. If your client in this situation didn't want his location information reported, he could have left the phone at home. He could have unsubscribed to that service. He could have done a number of different things. So where's the intrusiveness here? You've got the third-party doctrine, hey, I consented to Google to have this and to use it to target ads, and you've got what seems like an exceptionally minimal intrusion, just leave it at home.
Would that have been good advice
Or
for
don't
my
take it
client?
with you when you
Absolutely.
commit a murder.
That would have been excellent advice for my client,
And
Your
you
Honor,
understand
and I
this
wish
is
you were
very
his
valuable
counsel.
information for the police.
But on that note, the problem is that the consent becomes an issue then, and the voluntariness of it. And if anyone here has attempted to use a Wi-Fi, and you just click consent because you need to send work, or you need to sit there and check in on how the surgery went for your parent,
Then
I
you
would
consented.
submit that that is less
Is
consensual
there,
than the
is there a
court
difference
makes it.
between, is there a difference between transactional consent and the idea that just because you give transactional consent, you might actually be giving consent to a bunch of things that you're not aware that you're giving?
Yes.
All right, I think with that, you've reserved 5 minutes for rebuttal. We've held you over quite a bit. We thank you very much for your participation, and we'll hear you on rebuttal.
I would happily agree to grant my colleagues time to
We'll
answer
take-
all your questions.
We'll take care of it, don't worry.
Thank you, Your Honor.
All right, thank you.
May it please the court, counsel, my name is Jacqueline Hagan Doyer. I represent the state of Texas here today. Of the 54 words in the Fourth Amendment, we now have a vast and complex body of case law. And this case sits at the critical intersection of a cold case murder, a new investigative tool, and bedrock constitutional principles. But just one of those 54 words should be determinative in this case, though we have many other grounds on which we should prevail, because we are the prevailing party from the trial court. But that word is search. And the threshold question is, did
Well,
the search occur?
I appreciate you. I hope you've gotten through the opening you prepared to give
Oh,
before I've
okay.
interrupted you. But I just want to be clear on, can this court be in a position to do something useful in terms of stewardship of this issue, possibly before or after Chatry is decided, under the U.S. Constitution, our Constitution, and are we in a position, given the preservation status, to do that in this case?
Right, so with regard to the Texas Constitution, that claim was not presented to the trial court, and the third court noted that in footnote 1 of their opinion that that was not preserved, nor has appellant articulated how the Article 1, Section 9 would give him any additional protection than what the Fourth Amendment provides. So I don't think we're in.
How does a person in a trial court who makes an objection to an unreasonable search or seizure invoke the Texas Constitution? Is it like a federal pleading in a fraud case, that you have to start pleading line by line the sections of the Constitution that are implicated?
So in practice, what we've seen is they will actually file motions to suppress that cite to both amendments, the fourth in the federal Constitution and the Article 1, Section 9 in the Texas Constitution. We also look to the language. Have they articulated how the Texas Constitution, the state Constitution, gives you more protection than the federal? And that did not occur in this case. With regard to what this court can do pending Chatry, there is something that can be done because the appellant never met his burden, right? When you bring a Fourth Amendment claim in the trial court, it's your burden to establish all elements of that claim. And as I said, the threshold question is there a search? And that leads to, is there reasonable expectation of privacy? And there is a two-part question there. And the first part is there a subjective expectation of privacy? And there is case law directly on point that says you have to demonstrate that. He did not demonstrate that. We know from motion to.
We have this challenge, so
Sure.
we're dealing, I think you would concede, with an area of law that is developing fairly rapidly and not entirely clear at this point, given 4-4 split on this court, the U.S. Supreme Court looking at this, and how we would litigate this in a trial court is sort of what I view high court's jobs to be. So we have to do that in some case, maybe this one, maybe another one. And so how is someone in a trial court supposed to present the objection that I don't want my information my data being used against me, and does it matter that it's not just their data, it's potentially lots of people's data? I mean, isn't the argument that's being made in any Fourth Amendment or state constitutional analog to it, this was unreasonable?
Sure, but that's once you get to a search, right? And so that's kind of the second question. So again, if you want to demonstrate in a trial court that your rights have been violated, you have to demonstrate that you had a subjective expectation of privacy in that data. And he could have done that. He could have taken the stand for the limited purpose of establishing he had a subjective expectation of privacy. But set that aside. Look at the record. Do we have any objective evidence when you look at that record that he had that expectation of privacy? For one, this is a cold case murder. So the murder happened, the data that was collected was roughly 5 years old. In any of the time in the 5 years between when he murdered Miss Miranda and when that data was collected, did he delete the data? Did he turn off location services? No. That doesn't demonstrate a subjective expectation of privacy. He voluntarily opted in to Google tracking this information, and Google uses this as part of their business model. It's a huge revenue generator for them. They use it for targeted advertising, and so this is not something that is like, you know, if we get into Carpenter, this is very, very different than Carpenter, but he did not meet that burden to demonstrate that subjective
Nor would anyone
expectation.
in his position, in your view, right?
No, I think you could. I think you could take the stand. I think you could
Well,
say,
on this record, let's say.
on this record, no.
Okay. But let me just walk you back. I'm just starting with what's reasonable.
Sure.
Okay. I view that as a touchstone because I understand, that's my understanding of what the Fourth Amendment's targeted at. The implications of your argument with respect to the third-party doctrine would make this information, as to everybody in the world, available anytime.
And so I
Correct.
think what we have to be careful with when we're looking at third-party doctrine is just what is it, right? And it's basically if you have voluntarily exposed something to a third party, that's Smith, that's Miller, then you have no expectation of privacy, therefore a search has not occurred. As to the other people that might be present in the geofence when this type of information is obtained, well, a defendant or an appellant can't raise the Fourth Amendment rights of somebody else. It is particular to the individual. And to the extent that Google runs a filter or a scan, they're not searching. This is not a general warrant, which I would submit to the court. That has not been preserved. That was certainly not argued at the trial court level.
Is it possible that what is reasonable with respect to serious offenses might be different than what is reasonable with respect to petty offenses?
I think that's an argument that could be made, as however.
This was a murder,
It
right?
was a murder. I
Okay.
don't want to concede
But if the
that-
third-party doctrine is going to be an open book, Google's policies, I understand, require a warrant. But if you're right about the third-party doctrine, they could change that policy tomorrow, correct?
They could change that policy, but a private
Okay,
company's
so,
policy.
but even with the warrant, you're from Comal County, is that right?
Yes, sir.
I-35 runs through your county.
Yes, sir.
Right? There's a speed limit on I-35. Google has, by tracking data, the movement of everybody driving down I-35 with a warrant. I will submit, I could bet there's probable cause somebody was speeding through Comal County last night, and probably every night, going backwards for years. Google could, with a warrant, identify everybody who is traveling at faster than an average of 75 miles an hour through your county, and you could send them all speeding tickets, right?
Google could do that, yes, but
And if the third-party doctrine takes us where you would urge us, we would have that surveillance state available to us with Google partnered up with the government to engage in that level of scrutiny of our
I
citizens,
think
right?
you would have to look at, if you're talking about Google and a warrant and going, all around 35, then you're into particularity, and you're into whether this was narrowly tailored and narrowly drawn. And that's not the facts of this
But that's the problem with this
case.
area of the law at this point, right? We
Well-
don't have a person. The Fourth Amendment typically is targeted at a person. We know there's some person.
Well, typically, yes, but that's Zurcher, right? Zurcher v. Stanford from the Supreme Court. You don't have to have an identified perpetrator in order to search for evidence that is located on a third party's premises. So by that logic, you're okay to search a third party's premises. I would also caveat that when we get into talking about the warrants and the geofences, where these federal cases that have considered these and state cases have come down is how narrowly drawn were the geofences and how narrow was the time,
Right.
basically.
You hit on something that actually piqued my interest there about particularity. You said, well, now we're getting into particularity. So once we move out of things like just identity or location for people, but then we're not really talking about the third-party record doctrine or third-party doctrine anymore. Now we're talking about a warrant and probable cause. Because if the third-party doctrine extends as far as it logically should, then Google can basically, then you would be able to have a search warrant for this murder, and Google would give you all the records for all the cell phones around the area, and you might find someone that has, visited child porn sites on their phone, and then you could prosecute them for that, right? Because there's no expectation of privacy in the phone, unless we limit this temporally, locationally, publicly, right?
I would actually just kind of have a more nuanced response to that. As far as the third-party doctrine, if there's no reasonable expectation of privacy, there's no search, there's no warrant that's required.
Unless it's,
Right.
unless it's
that's
property.
one-
That's exactly
so
the
that's
problem,
one
isn't it?
thing. Well, but then to that extent, then the person needs to not consent. They need to not opt into this data sharing. And this is not Carpenter.
That's
You are
important.
not-
Let's focus on that just for a second.
Yes. You
They
are-
opt in to use these services.
Correct. The
They don't
concern,
opt out to not. They opt in. So the example of the people driving up, down 35, if they don't want to be tracked for the potential of speeding, don't take your phone or
Well,
don't.
wait a second, though. So I'm really excited because the World Cup's about to start. So if I grab the microphone at the Cowboy Stadium and there's 100,000 people there, and I say, who here consents to have Google to have your information? Everybody goes, we don't. And they go, how do we turn it off? And I go, I don't know. And I just drop the mic and walk away. Like, haven't they kind of indicated through a voice vote that they have given away their consent? They've revoked their consent, but they don't know how to technically revoke their consent. Like,
I would have a lot of follow-up questions. What does it mean for them to revoke their consent? Did they knowingly, what do they even know
we
what
talk
it
about-
means? Because there's
yeah.
also a difference, even, council was misstating the difference between location services and location history data. Those are two very different
no, I know, but I guess
things, and so-
my point is, like, we talked about, people keep saying opt in, well, you opt in and you consent.
Right.
But if I don't know how to withdraw my consent, it's like if I go to an interrogation room with a police officer and I say, yeah, I'll talk to you, and then halfway through I change my mind, like, all I have to do to let the officer know I've changed my mind is say, hey man, I don't want to talk to you anymore without a lawyer. In this case, candidly, after Wells, I went through my phone because I was like, let me turn all this stuff off. I'm sure I didn't turn it all off because I don't know how, because I'm 53 years old and I'm stuck in an 85-year-old's mind. Like, I don't know how to do it. So how do I do it? Like, how do I withdraw my consent? Do I have to send Google a certified letter telling them
You want
stop
me to
doing
work
that?
on that with you later?
Thank you. I appreciate that. I need all the help.
We can help.
I would say that the question before the court is, does the third-party doctrine apply? And third-party doctrine looks at, is something voluntarily exposed to a third
But
party?
but
That
how,
is the
how after
question. And
Carpenter
he-
does that work? I mean,
So
in Carpenter, you
Carpenter-
were targeted one person who was using a phone. You knew who it was. You were looking for a phone number. Here, it's a shotgun blast across the planet where everybody whose device might have been in the area, and they consented to using the service, but for what purpose?
So
right?
I would distinguish Carpenter on several grounds. One is, it's not a shotgun blast. Like I said, we have these two very narrowly drawn geofences.
That,
where the
that,
victim
that's helping
was
you with reasonable, right?
murdered,
Yeah, right.
where the victim was murdered and where her body was found. So we're not talking about a shotgun blast. But as far as Carpenter did not go as far as Appellant claims that it did. It doesn't say that all location history is now King's X on location history because it's location history. No, what it said was it's a narrow holding. It's only applicable to the questions in this case, which was 127 days of data, and they said no reasonable expectation of privacy in 7, right? So they never reached this. And then Sims, our case, kind of fills in the gap. Well, no reasonable expectation in 3 hours. And frankly, this warrant was less than that. And so we're not in territory that is really governed by Carpenter so much as we're outside of it. We're looking at what they said didn't apply. 'Cause
But
there
doesn't step 3 allow for 6 months of IP data, would go outside of Carpenter?
It does allow for that, but that was not returned in the warrant, so there was no,
Wait a minute, this one was very narrow on the third step, right? I mean, Detective Mahoney on that third step went with 1, which was just this one, and the only thing he got was a name, email, phone number used to create the account, and the date and time the user agreed to the terms of service.
Correct.
At step 3, that's all he got.
That's all he got. Then he got a second search warrant to get the further data on this particular
So he
appellant.
did go to a magistrate to get the additional information, unlike in Wells.
Yes.
What was the additional probable cause for the second warrant, though?
The pattern of travel that was consistent with a tip that one of the
Okay.
detective had gotten, that somebody had come from San Antonio to New Braunfels, murdered her, and then returned.
Okay.
Do people have a reasonable expectation of privacy in either their presence or absence from the scene of a murder?
I would argue that they do not, and even if they have a subjective expectation of privacy, it's not one that society would be prepared to recognize as reasonable.
And let me ask you one more question about, because there's, there was some discussion in our Wells opinion about the third category, the third license, I guess, that was provided. If a warrant were to authorize the search of a car, a house, and an outbuilding on the property, and it turns out that the affidavit looking for that warrant provided probable cause to search the car and the house, but not the outbuilding, and the police went to the outbuilding, but they didn't find anything that they used against the defendant, is there anything for the courts to do about that? Aside from perhaps allowing a civil lawsuit for the invasion of the outbuilding?
Perhaps for trespass of some sort, right? But no, I mean, the question is, did the officer violate in some way? And if they stuck to the scope of the warrant, then you would be within.
I mean, if
what
they
is
stuck to
allowed.
the scope of the probable cause and they found evidence in the car and in the house where they had probable cause, that wouldn't be excludable merely because the warrant also authorized the search of a place where there was not probable cause, would it?
Correct, because then you would just look at anything that would have needed to have been excluded by virtue of that additional authorization but from the warrant, and so we don't have that. And it is our position that this warrant at the outset gave probable cause as to all 18 devices.
Counsel, I have a question. This, I think you've already said that when we get a cell phone, we're agreeing to location tracking services. My first question is, are the terms of that agreement in the record?
They're not in the record, but that would be appellant's burden to have demonstrated that at the suppression hearing.
Okay. Well, another thing is, I'm assuming that when I bought my phone, a few months ago, that I probably signed a document that was pages and pages and pages of agreements to do this and that, and chances are I didn't read it, I just signed it. And that's probably what most people do. Would you agree with that?
God, I hope not. But
Well, I think
as
a
an
lot of
attorney, I
people
hope
do.
not.
So my question is there so much stuff in these agreements that we have to agree to when we get a cell phone? So many different, it's so intertwined that we really didn't agree to it.
I think what you're getting at is a question of voluntariness as to the opt-in and the evidence before the trial court, right? Because that's what we're here to look at. Did the trial court err in denying the motion to suppress? The evidence before the trial court was from Detective Mahoney that these people opted in, and there was no evidence to suggest that it was involuntary. And so and when we look at the trial court record and we make every assumption in favor of the trial court's ruling and the state is the prevailing party, we don't have anything to suggest it was involuntary.
This is predominantly a legal problem, isn't it? And we're navigating fairly new waters here.
They are fairly new, but I do think this court could resolve it simply on him not meeting his burden. I think you could also get to look at Wells, and it's kind of interesting, I hadn't gotten to address this yet, but the question that was presented was, did the third court err in considering Wells binding? And I will point the court specifically to 248 and the third court's opinion. They said they used the court's reasoning as well in Wells as a guide.
We're not in the third court anymore, are we?
No, but they used it as a guide. And that question, is it binding? I think we would expect an intermediate court of appeals to look at the high court and use that reasoning as a guide. But moreover, there are actually 5 judges from the Court of Appeals, when you parse through all of those decisions, that agreed at least there was no expectation of privacy as to step 1 and step 2.
Well, right.
And so to that extent,
I find it very interesting. I've read these cases and a bunch of others. I was in the penalty box for Wells, so I did not have a view on that. But
I have a question for you.
in every one of them,
Sorry.
we find the same thing, that the detectives have tried every other means before they go and pursue one of these warrants. That's a basic human intuition and instinct, right? I mean, everyone seems to sense this is different, right? This is potentially a much bigger deal, and the parameters around this, it seems intuitively need to reflect the reality that the framers intended a rule of reason to apply to all of this. Driving by my house and being able to see through my walls and with the heat
Thermal
sensing.
imaging, yeah.
Reason is what's going to have to govern here, right?
If you get to the question of whether there was a search, then yes.
I just want a point of
Oh, that's great,
clarification.
that's
Go ahead.
No, I was just, I was curious because there's a lot of, I think, concern because most of us judges are not spring chickens. And with regard to this opt-in idea, but really, I mean, the duty is on us as the consumer. And there needs to be changes in terms of legislation. But our job today is not to legislate changes to protecting consumers here in the criminal court. So we currently have this law, and I would just, maybe it's a statement, but I'll put it as a question. Is our ignorance an excuse for our agreement to opt in?
When people set up these accounts, they do have to walk through a process by which they opt into the location services. And so I think that it's made out as, something that maybe it's not. And people do have to affirmatively select that. And when you look at Miller, for example, when he turned his checks over to the bank, it's not like he was told right then and there, hey, we might use these in an investigation. These might get turned over. He wasn't told that. And so it's not based on the wrongdoer's misapprehension of what is going to happen to the data. That's Hoffa, that's the Miller case, that's the Penn Register case, that's Smith v. Maryland. So it's not so much based on that.
That's actually a good point. The Penn Register cases and Miller, these are all cases, though, we're talking about a discrete amount of information, not the wealth of information you can get when you interpret consent beyond sort of the transactional use of an app to now Google can track me for the rest of my life. I mean, come on. Everyone here has probably had the moment where I'm going to see where I've been, and I'm going to look on Google Earth, and it's like, holy crap, remove all references to Ron Swanson, really, it's just, it seems like there has to be a limit to what you could say you're reasonably consenting to when you opt in.
Isn't that what Carpenter said?
Yeah.
Well, Carpenter.
The reality is, you could buy a string and a couple of tin cans, or you could run around with a megaphone. But if you want to live in this world, you really don't have a choice to say, I don't consent, right?
You do have that choice, right? Because in Carpenter, the issue was this information is automatically collected, just automatically generated by no affirmative act of the user. And this requires an affirmative act of the user.
Let me just point out two things. You can't even go to an airport right now and park without having to upload everything from your cell phone into their app. You can't even pay if you want to. And I guess my question is when a lawyer makes a valid objection that the cell phone information was not lawfully obtained, does the state have any duty to show that the defendant did not opt out or consented to that information being distributed? Does the burden shift to the state at some point?
When they bring their claim, their Fourth Amendment claim, it's their burden to establish every element. Part of that is the subjective expectation of privacy. And when Detective Mahoney testified, this person opted in, they've met their burden.
Does the
Detective
record
Mahoney
reflect
was-
that?
Yes.
Okay.
Isn't there a difference between location history and phone data?
Yes.
Yeah.
It's a much narrower set of information, right?
Yes, I mean, when we're talking about the cell phone that's actually carried around with you, this is Riley, right? That this is an appendage, basically, and it contains all of this information. That's very different than, yes, Google, you can use my location information to provide me ads, to
Right.
track my location. I can turn it off if I want to. I can delete data if I want to.
I mean, Penn Ridge, for example, they're going to you can't really say you have an expectation of privacy in your phone number if you have to link up to somebody else seeing they received your phone number.
Right.
Right? So that's a very limited sort of information dealing that is limited to sort of location and temporal and publicly viewable stuff. But it's not as expansive as, say, all the stuff that's on the phone, which is where the concern comes in with 6 months of IP addresses, even though that's not this case, that's
Right.
other cases.
Right, yes.
If the legislature of our state is concerned about people's privacy and their location, could they pass a law that says that internet companies cannot track location in this state?
They could do something to that effect. They could address how the data is stored, how it's anonymized. All of these things are policy questions and issues that could be addressed by the legislature.
So does that mean that what we're really being asked to do is to act as a super legislature to create rules that the legislature could create itself if the people demanded it?
if you got to any of those questions and you were asked to do that, I would say that's not this court's role. This court's role is to look at the Fourth Amendment, that very particular claim, the burdens that apply. Did he meet that burden? And if we even get to the question of whether there was a search, then if we get to that question, frankly, we look at how particular and narrow the geofences were, the temporal, the time, the facts of the case. We rarely have, what we always say in trial, is we rarely have an eyewitness to a murder. We had a 911 caller who called as she was screaming, hanging out of the vehicle, right? This is a very, very specific case that justified these 2 warrants and the time frame. And frankly, everyone who was in those geofences at the beginning, there was probable cause. How it was executed, different question, right? But we had probable cause at the outset.
More questions?
No, let's move on.
Yeah.
Nice pause.
If there are no other questions.
If there are no further questions from the panel, I thank you very much for your time and your helpful argument. We'll hear from some rebuttal.
Your Honors, this is obviously not going to be something where everybody's going to agree right away. However, if the court is looking for something it can do within the parameters of the questions it granted, it can speak to the state constitutional limits on either technological advances or simply the third-party doctrine, extending Holder and looking at that in those terms. I think that would be a logical place to start.
I'm just trying to, how would you ask us to draft an opinion that limits information that is available to the public or through a third party, such as I mentioned, airport? If you go to any parking place now in Austin, San Antonio, you have to log on to your cell phone.
I think
where do you draw the
presiding
line?
judge actually may have hit on it in the sense of if this is treated as, perhaps not a bailment exactly, but if it is treated in line that we contract for a limited purpose, that doesn't mean that we permit a third party to give that information without warrant to law enforcement. And I think that's something. I'm sorry?
It sounds like a legislative act to me, rather than a judicial act.
I don't disagree that it's certainly something they could do, but it is also something, in fairness, this court could do. While it is a matter of restraint, I think, in fairness, this court's own holdings on this issue actually
Your
lead
earlier
us there.
argument with respect to bank deposit boxes, right? I mean, you have given it over to someone else who physically owns the property, and you have, but when you sign that agreement, you probably agreed to some circumstances where somebody might come and look at it. Doesn't mean necessarily, though, that you agreed that anyone could come in at any time without a warrant based on probable cause that's reasonable to come into your box, right?
And I'm not asking the court to change the sensible, reasonable requirement. I'm simply saying that because nowadays, because the amount of information that one sadly has to give up in order to get access to a system, it seemed reasonable that there could be limits placed upon that, at least for law enforcement. They would still have to, as they would with a safe deposit box, because I put personal things in it.
Well, let me ask you, following up on Judge Richardson's question, have you seen a piece of legislation in the history of this state that defines what property is?
In terms of digital information?
What is property?
Not for digital, no, sir.
Okay.
I mean, we have the property code, but it never has addressed this. I think that is a valid point in the sense that it's also time for the legislature to step up.
There's such a thing as a data broker.
Pardon me?
There's such a thing as a data broker, right?
Yes,
What are they selling?
our data. But that is not covered for law enforcement purposes. And at least something that the court could suggest to the legislature would be, I think, in that realm.
I have a question for you regarding the position that the state took that said you did not meet your burden to show that there was a subjective expectation of privacy because there was no evidence provided that the opt-in was involuntary. So there's an evidentiary burden there even before we can reach the bigger legal question. I'd like to hear your position on that as to whether or not the evidence was presented that this was involuntary.
I think you are shifting the burden, although in fairness, there are affirmative defenses that you could analogize this to. But I would suggest that a remand with that guidance, so evidence could be presented as to whether it was voluntary or not, would be the appropriate standard. And I think that that makes sense, both as a bailment.
But I understood the state to say the burden was on the defendant who was making this objection during the suppression hearing, I believe, and that burden was not met because there was no evidence put on during that hearing that the opting in was involuntary, or that it even an argument that, okay, yes, I signed this, but what was I supposed to do? In order to park, I had to agree to this, you know? So because that's the first question we have to get to. You know, what evidence was put on by the defendant that there was a subjective expectation of privacy before we even get to the bigger legal question?
I think Your Honor respectfully asked a good question, but it's proceeding from the wrong premise. And this is that they knew that they had to provide this. I think this court could give them guidance that such would be provided, and in accordance with that guidance, you can remand it for a hearing as to whether or not that is going to be done, or for future cases. I think not knowing that you had to put on evidence of the voluntariness or the involuntariness of the transaction is something this court could give guidance to, and whether it decides to make it an affirmative defense of the defendant or a shifting burden as suppression can be, that would be up to the court.
So you're saying you didn't have to provide evidence that there was a subjective expectation of privacy. You just make the subjection, you don't provide any evidence, and then we can make a decision on it. That's what I hear you saying.
Well, no, that's a mischaracterization of what I just said, Your Honor. What I'm saying is that if you're going to make a legal requirement that has to be known to the litigants, so that, for instance, in fairness to my colleagues, they could produce via subpoena a copy of the contract that said clearly it was voluntary. If you are giving guidance to the courts below you to establish a fact pattern that you have to give deference to, in respect, I think that you're obligated to provide that legal guidance, and that would be this opportunity.
It seems like that burden was already there for the defendant.
No, Your Honor. There's no, remember, when you raise the issue, it becomes a shifting burden so that the state has to prove that, for instance, they had a warrant. I believe that that was raised. I believe that the state failed here, and not my colleagues, obviously, but Detective Mahoney failed here to get in step 2 a magistrate to look at this and say, okay, this is okay.
Well, I understand that, and I want to join in on Judge Parker's concern about the disposition of this particular case, which is in front of us. But I'm going to go back up to a high level here. We don't have a 5-vote majority from this court or from any court that matters other than the Fifth Circuit, who has gone a very clear direction
On Smith,
your way.
yes, Your Honor.
Until we have that, in your case and everything else that comes after it, we have a good faith exception that's applicable to all suppression motions. And you've seen a lot of opinions from other courts where a lot of judges have said, how can you say this was done in bad faith until we have a meaningful standard for the officer and the magistrate issuing the warrant to follow? It's kind of hard to criticize them for doing it wrong until we set a standard that is going to be applied. And the more geofence warrants we get, the more need there is for a standard so that we have somebody to be operating either in good or bad faith.
I'm sympathetic to that, Your Honor, but the problem is that here, the officer did not follow those procedures in the sense that he omitted the fact that he expanded the request. So if you're going to argue good faith, good actions that are clearly done and transparently done, I would say are a requirement for good faith, and that fails here.
But did the magistrate require him to come back for that step in the original warrant?
Yes.
Okay.
So the Fourth Amendment secures persons, houses, papers, and effects. Which of those is at issue here?
I'm sorry, sir. Could you clarify?
The Fourth Amendment, which I think is what everybody's relying upon here, it secures persons, houses, papers, and effects. Which of those is at issue here?
I would say digital are both papers and effects, is the closest thing one can look at in the sense that
And if you're talking about location, persons.
I think also if you go to, you're searching a general area, not a specific person, then we are back in the territory of general warrants, which don't have to require force of arms to
Where
enforce.
does
It's simply done
expectation
with
of
a button.
privacy fit into persons, property, or effects?
I would say it's all of those things.
It's judge-made law, right? Based on what's reasonable.
Yes,
And we're navigating new.
we're
areas.
navigating murky waters. I agree with the court.
Counsel, let me ask you this question. I ask the state this, the agreement for the location tracking services, are the terms of that agreement in the record?
I think agreement becomes the issue here. In other words, if I have agreement to share that information with others, for instance, if one takes the example of the app that allows you to track family members on their phones, you can treat that as analogous to this. If I agree to this app, I'm agreeing to track others and myself so they can reach me. I think you start getting down that line. If you're not specifying that you agree that this information is going to be shared with law enforcement, then the default should be no.
Counsel, I got one final question for you. Fourth Amendment protects against unreasonable searches. And just like Judge Shank said, reasonable implies a balancing necessarily. This was a cold case, and the state clearly has an interest in solving murders. Was there an alternative way? Was there a less intrusive way that the state could have obtained the identity of this suspect?
I want to preface this with, I have two brothers that were on the job. I have great sympathy for this and for this individual detective. But yes, and this is
What was
where,
it?
based on these facts, there were accomplices that were actually locatable and who could have been found from the reports of the other people in the apartment who had knowledge of their existence. Now, again, it's possible.
So knocking
that-
on doors, just knocking on doors?
I'm sorry?
They could have just knocked on some doors? Is that what you're saying?
I'm just saying old-fashioned police work would have worked here on a cold case. And for the vast majority of cold cases, that is what solves it, is re-interviewing the same witnesses that denied it. And here, first off, I commend Detective Mahoney's diligence. I'm simply saying that there were less intrusive ways to get the same information and get a name that he could have then run.
Isn't this sort of analogous to a lot of cold cases are solved by analyzing DNA material that was left at the crime scene 10 years later? This case was solved by analyzing geolocation data that was left in the cloud 5 years later. Isn't there an analogy there?
I think that's a fair analogy, Your Honor, except that they're a different context in this, because DNA, if left at the scene and simply was not testable 20 years ago, that's one thing that certainly does come into a forensic play. But here, an electronic footprint is now virtually forever.
Yeah, but the suspect can't delete his DNA 10 years later. This suspect could have deleted his location data at any time.
But the DNA evidence was discrete and seized at the scene. This isn't a search for a bunch of different information.
Well, but DNA also requires a warrant to get.
Right.
So I think at this place, we're still at the same
Well,
position.
not unless it's an Ancestry or 23andMe and your sister gave it to them.
Yeah.
Without your knowledge.
Along that-
Or you're in the state's database because you've been previously convicted of some crime and they
Right.
put you in that database. Your DNA is there forever.
That, if you're saying punting to the, not
Well, I'm
passing to the legislature for that
just
requirement,
saying
that's a good example of that.
you don't consent to
No.
that. You have to give it.
That is true. And that was decided by the legislature, not by a court. So
think we
that
have-
is a valid
I
point.
think we have one more final question from Judge Uri.
If the police did not find this defendant's device at the scene of this crime, but if they found the devices of all of his buddies, and they found him because they found his buddies there, would he have a gripe about an invasion of his privacy?
If I can understand your question and draw an analogy.
Sure.
If I dropped the little paper
Let's say he
notebook
didn't
that I
bring his
carry,
phone. Uh-huh.
it's abandonment. And if I dropped either a weapon or a notebook
I
that
think you're
had it.
misunderstanding, okay? Let's say that all 9 of us decide to go do a crime somewhere, and we adventure off out of this building, and we go to commit the crime, and I leave my phone behind, but I am the guy who does the actual crime. And then I get prosecuted for it because you find all their phones, and they're all like, Yuri did it, right? Do I have a gripe about the police having searched the location history of all my buddies here?
If you're, I'm not sure where you're going. If you're asking standing,
Well, I'm trying to figure out, is the invasion here an invasion that's specific to the defendant, or is it an invasion that goes to everybody in the whole world?
well, on that, I have an easier answer. A general warrant, every fish in the net has a right to stand up and say, this net was cast too broad. And that's simple on a general warrant, if you decide that this is a general warrant. If you're not, if you're saying that there's a continuum with geofencing, which I think is where you're heading,
Not sure, but
this end, and I think where Judge
Well,
Finley
there
was
could be
at.
such a thing as a hybrid warrant, right? And
but
the
it's
Fifth Circuit
a-
said this is a general warrant, but it could be that for serious offenses with narrowly tailored to protect warrants with judicial oversight, there could be a different process here, right?
I think that could be a posture, particularly in a cold case. So,
thank you.
with that, Your Honors, thank you for your time.
Thank you very much. Thank you both, counsel. With that, we'll take this case and all other cases today under submission. We'll stand in recess.
Oyez, oyez, oyez. The Honorable Court of Appeals now stands recessed.
You were so calm and